On a couple of promising decisions in alien tort statute cases. And this week, we're going to be looking at two other important developments that have taken place this year. First, we'll hear about the Ratha case, which was litigated under the trafficking statute. And after that, we'll discuss the Doe v. Exxon litigation and the settlement that took place this year. But before we get into those cases, Kathy Sweetser from the Promise Institute, which is also our co-sponsor, is going to give us a brief synopsis of key highlights from last week's webinar. If you missed that session and you want to watch it, the recording is available on our website, and we're posting a link to that right now in the chat. So Kathy, I'm going to pass over to you.
All right, good morning, everyone. I'm just going to give a very brief recap of the two cases we talked about last week, which was Al-Shamari and Cisco, and just three key takeaways that we were talking about as we were discussing last week. So first, we talked about Judge Brinkema's opinion in Al-Shamari, and we talked about this question of a sufficient domestic connection between the case and the United States. So as you guys probably remember from last week, we were talking about a case that took place on a military base in Iraq, so it wasn't necessarily within the United States, but we talked about the different territorial connections that the case had, and that it wasn't, under Judge Brinkema's analysis, it wasn't necessarily limited to the conduct in the United States, although there was a lot of supervisory and monitoring conduct in the US that did happen there. And then we talked about the Cisco case, which was a case about religious persecution and torture in China. And we talked about how domestic violations of international law actually make things territorial under Morrison. So in that case, we were talking about aiding and abetting standards and how aiding and abetting in the United States is a domestic violation of international law. And so we talked about the connections these cases had with the United States and how strong these connections were. And finally, we talked about the importance of factual investigation to draw these connections between corporate conduct and what happened abroad. And so it's something that's really important as we as plaintiff lawyers continue to bring these cases, to have a really strong factual investigation and to make sure that we know what corporations are doing and where they are doing it. So that's just a very brief overview. And those were, as Charity mentioned, two ATS cases. And today we're going to talk about two more cases that were brought under different legal schemes and how those cases progressed.
Great, thanks for that synopsis, Kathy. So before I introduce our speakers again, a quick logistical note, we are going to reserve 10 minutes at the end for questions. So feel free to use the chat during the panel, but if you have a question, put it in the Q&A. I'll just say for our last webinar last week, a bunch of really great questions came in at like 3 minutes before the hour. So if you want us to address your question, I encourage you to do it before we get to the Q&A session, so about 10 minutes before the end of the hour. Feel free to enter questions in the Q&A throughout our session today. Also, feel free to drop your name and where you're logging in from in the chat. And then also we are recording this webinar, so everyone who's signed up is going to receive an email with a link to that recording in the next few days. We're also going to post it along with last week's recording on the CAL website on our events page. So with that, very quick intro of each of our panelists. We are posting full bios in the chat. They all have long, distinguished careers that you should know about. So panelists, if you want to turn on your video and join us here, I will give these quick bios in no particular order again. Katie Gallagher is a senior staff attorney at the Center for Constitutional Rights, and she is counsel in the Al-Shamari case we discussed last week. Terry Marsh is the executive director and founder of the Human Rights Law Foundation, and she's counsel in the Cisco case that we also discussed last week. Kathy Sweetser, who you just heard from, is the deputy director of UCLA's Promise Institute for Human Rights, who's co-sponsoring this event. She's also the director of the UCLA Human Rights Litigation Clinic. She is counsel in Cisco that we discussed last week, but also both cases we're discussing this week, Ratha and Exxon. Agnieszka Fritzman is a partner at Cohen Milstein, Sellers and Toll, where she's also the chair of the Human Rights Practice. She's counsel on both the Exxon and Ratha cases that we're discussing today. And then we may or may not have Paul Hoffman back with us this week. He's having some technical difficulties. He is a partner with Schonbrun, DeSimone, Seplow, Harris, and Hoffman. As we discussed last week, he's argued a lot of Supreme Court cases, a lot of alien tort statute cases before the Supreme Court. He's also counsel on Exxon and Ratha that we're discussing today, as well as Cisco that we discussed last week. So hopefully Paul will figure out his tech issues and join us. So I want to start by talking about Ratha v. Fatana Seafood. Kathy is going to talk to us about this case, although since Agnieszka is also on it, maybe she will jump in as well. So this is a really important case filed under the TVPRA, but unlike the two decisions that we heard about last week, it's a little bit less of a beacon of hope than our ATS cases. Can you tell us a little bit about the facts of this case, Kathy?
Sure. So, as you mentioned, this is a trafficking case. It concerns 7 plaintiffs who were trafficked from Cambodia into Thailand. And these plaintiffs were trafficked to work at a shrimp factory, as a shrimp processing factory. Um, I'm sure many of the people who are attending this webinar are familiar with the rampant abuses that take place within the Thai seafood industry and the Thai shrimp industry. And we're not talking today about some of the things that have been more reported, such as like the abuses on the boats or in harvesting shrimp, but we're talking about a case about a factory where people were processing shrimp. And some of the ways that you do that are including like cleaning the shrimp, cutting the shrimp, making sure the shrimp is ready for sale. And in this factory, there were some really egregious practices going on, including an amount of chlorine being used that was really toxic and hazardous. And the people that were working in the factory were not given any of the proper protective materials. So our plaintiffs who were living in Cambodia at the time they were recruited to work in this factory were made a lot of promises about how much they would be paid, about the fact that this would be a lucrative opportunity for them. But in fact, the recruiters and then the people running the factory were in fact using fraud, coercion, and in some cases even violence to make sure that people, once they signed up, they paid a large recruitment fee, they weren't able to leave again. And that they followed through with coming to the factory, and then they were threatened with arrest. They had their passports confiscated, and they really were not able to leave. One of our plaintiffs, his mother died while he was working at the factory. So of course he immediately wanted to return home. He wanted to attend her funeral. He wasn't given his passport back. He wasn't allowed to attend her funeral. Um, while people were working at the factory, they weren't paid what they were promised. They were told they were in a great deal of debt. The passports would not be returned until they had cleared that debt. So it really was, forced labor. It was peonage. It was, a modern day form of slavery, really. And so we sued the 4 companies that were responsible for this. They're in a venture together. Rubicon, which is a Los Angeles-based, Culver City-based actually company. And I find this significant because I'm currently in Culver City right now. That is where I'm based. So it's a very local and relevant case for me because they're basically around the corner from me, this company. And then there were 3 Thai companies that were also involved who had the nominal ownership of the factories. The workers had a lot of consequences and harms from this trafficking as well, long term. So they're ultimately able to leave the factory and get back to Cambodia after NGOs discovered what was going on there. They were ultimately able to escape that situation, although left in a very much worse situation, including having a lot of different medical problems. People were having long-term respiratory issues from what they were exposed to. They had nausea, vomiting, gastrointestinal difficulties, and many of their families were in a worse position as well because they had been forced to go into all this debt. And people at home, who got sick couldn't afford medical fees. It really, it was just a devastating experience for all of them. So we did sue in California and tried to hold the traffickers accountable here under the TVPRA. So that's the basic overview of the facts. I don't know if I should continue with more.
Yeah, no, that's really helpful, Kathy. Maybe just to step back a second before we go further on this case specifically. I know some of our audience is probably not familiar with the TVPRA, and this is our first discussion of this statute in this series. Could you just quickly tell us about the elements of this statute? What do the plaintiffs have to show to prevail in a TVPRA case?
Sure. So in a TVPRA case, this is a trafficking case. It's a set of criminal and civil provisions in the U.S. Code. So the forced labor provision in particular is in provision called 1589. And that provision provides that if you are using forced labor, it can be through a series of things. So when you think about traditional, but the popular conception of slavery might be using violence, but there's actually a number of things under 1589 that cause someone to be trafficked. So it can be force or threats of force or physical restraint. It can also be serious harm or threats of serious harm or abuse or threatened abuse of law or legal process. And what does that mean? Well, in our case, for example, an abuse of the law is something like telling all the plaintiffs, if you leave the factory, you're going to be arrested. So that's like a threatened abuse of the law or legal process that they're going to use the police to arrest people if they try and escape. And then there's also by means of any scheme or plan or pattern that would cause a person to believe that if the person like left or tried to escape performing the services, that someone else would have serious harm or physical restraint. So in our case, we definitely had serious harm. We had abuse of the law. And then there's also another title under this provision, it's in 18 USC, which is about document capture, so document servitude. So here they took the passports and they wouldn't give them back. So that provision also applies.
Great, thanks, Kathy. So, what happened on appeal last year and why are you seeking to reopen this case?
So on appeal last year, we had a decision by the Ninth Circuit that first, that the Thai companies were not subject to personal jurisdiction. So that was an issue about whether or not there was a sufficient connection to the US, again, as we were talking about, but it was based on the personal jurisdiction and the present in language. And so that basically the court found that because the harm suffered was suffered abroad, that even though they intentionally directed their actions toward selling things in the United States, that it did not meet the personal jurisdiction standard. But then there was also this company, as we mentioned, Rubicon, which is based here in LA, very local. And that company, there's a question under the statute of whether a company has knowingly benefited. And so the court mistakenly held that attempt to benefit was not included in that provision, but that has been since clarified.
Great. Just as a follow-up on that, the amendment that clarified that statute was called, I'm looking at the decision here, the technical and clarifying update to civil remedy. And it looks like the court held that it was not clarifying and that it was actually substantive, even though it's called technical and clarifying. Can you speak a little bit to that? How could the court have found that it wasn't clarifying? What do you think the reasoning is there?
Well, that was a district court opinion there that found that it wasn't clarifying. So we are seeking to reopen the case right now, and that case will be on appeal in the spring. So we're waiting for a decision on that, the clarifying amendment. But basically what happened is that earlier, I think it was in January of this year, Congress did clarify that attempt to benefit is included in the statute, that it was always included. And so now it's been clarified by Congress itself.
Great. So let me ask some questions for the group here. I'll put this out and anyone can respond. So I guess my first group question on this case is, do you think the TVPRA is a good alternative to the Alien Tort Statute for slavery and trafficking cases? Last week we talked a little bit about the torture statute. If you had a torture claim, bringing it under the the torture statute versus the ATS. Now, sort of the same question. If you've got a slavery or trafficking case, is the TVPRA a better alternative to the ATS? Anyone can take it. Go ahead, Agnieszka.
I think it is an alternative. I don't know that better or worse is really, I don't think we need to decide that, but it is an alternative, and Congress expressly made it an alternative and made it a powerful tool. Congress decided intentionally to fight trafficking on all fronts in a variety of ways through like the CHIP report, the name and shame, the Tariff Act to preclude goods from coming into the United States, and to give victims of trafficking, including victims of supply chain abuses overseas, a remedy against the perpetrators who benefit from that trafficking and forced labor. And they did that expressly and intentionally and in a positive statute. So you have the benefit of a positive enactment that courts can interpret in accordance with traditional principles of interpretation. And I think Congress intended it to be a powerful tool and to be used in this way.
Great, thanks. Does anyone else want to speak to that question? Is the TVPRA a good alternative to the ATS? Or any pros and cons of using one statute versus the other? Yes, Katie.
I think with all of these possible alternatives, just building off of what Agnieszka just said, the important thing is it's not an either or. And Congress has been very clear with these additional statutes that it is not taking away what was given in 1789. And so to the extent that there is a argument about occupying the field or something that we might be familiar with from a Bivens type analysis of, there's an alternative scheme, I think that we have to push back on and ensure that the Alien Tort Statute, to the extent that it may have been narrowed, it still exists and provides a basis for jurisdiction. So seeing these as a complementary almost system of enforcing human rights norms and human rights values, I think is maybe a different way to think about it than a choice.
And what Katie just said is there's strong legislative history in both the Torture Victim Protection Act and in the trafficking statute that indicate Congress wasn't trying to occupy the field and was preserving remedies under other forms of law. And I wrote an amicus brief for members of Congress along with the Human Trafficking Legal Center that outlines the history of the trafficking statute that we have on our website if people want to look at it.
Great. And if someone can grab a link to that and post it in the chat, I think that would be great. I'm also seeing a little bit of what Bill Dodge is saying. Let's bring in the extraterritoriality issue here, right? I think last week we talked a lot about extraterritorial application of the Alien Tort Statute. Do we have any concern about the federal presumption against extraterritoriality being applied to the TVPRA? I mean, it seems from my own read that most courts don't seem to think that it does apply to the TVPRA. Why not?
So Bill Dodge and I wrote an amicus brief on extraterritoriality that I will post a link to. And I think Bill has an excellent blog post on the transnational litigation blog that runs through the arguments on extraterritoriality. But yeah, the TVPRA is expressly extraterritorial and extraterritorial in exactly the way that RJR Nabisco says it ought to be, which is that the civil remedy directly incorporates the predicate crimes that are themselves extraterritorial. So it's a strong textual statement that the statute is extraterritorial. And I will either now or later post a link to that amicus brief. But I think Bill has the brief up on his transnational litigation blog, which is an excellent resource.
Perfect. Yeah, and actually, I'm glad that you brought up the transnational litigation blog. If folks are interested in these issues generally, that is just a wealth, just such an extraordinary resource. So please go poke around there if you can. And anyone who wants to post links in the chat to specific pieces, please do so. So I guess my one other question on the TVPRA before we start talking about the Exxon settlement, thinking about the history and amendments that Agnieszka just mentioned to the TVPRA, it just seems abundantly clear that Congress really wants this to provide civil remedy to victims of trafficking and not just under really specific circumstances, but a really robust kind of remedy. Do we feel like this is working, and do we need further legislative fixes to the TVPRA to make sure that it is actually providing the level of remedy that I think Congress intends?
I mean, I would say I hope that we don't need any further legislative fixes. I think what you're saying is right, that Congress has been extremely clear here. They've done everything they can to overcome any presumption that it would not apply. And so, barring any other court decisions that go the opposite way of all the court decisions that Agnieszka and Bill cited in their amicus, it seems like Congress really has met the bar that the courts have set. I do think there might be an issue in the future of courts really requiring just an extremely high hurdle of Congress, which I think has been happening in a lot of different areas of law. But really, I think judicial deference dictates that judges actually allow Congress to speak, and when Congress speaks so clearly, that judges follow that.
Great. Does everyone agree with this? Does anyone else want to weigh in on whether we need legislative fixes?
No, I think I agree with Kathy. I think, this statute has kind of a complicated structure, which has sometimes caused district courts to go awry, and it's been a little hard to interpret in parts, but I think Congress has made its intent really clear and recently reaffirmed that and clarified it, in the Abolish Trafficking reauthorization. So I think Kathy's right.
Great. Well, let's get Exxon on the table before we have more of a group discussion. So this is the second case we're going to discuss today. This is one that folks may have seen in the news because unusually there was actually a settlement in this case. And I think, as we've mentioned this last week, these cases can drag on for many years and settlements are fairly rare. This case has certainly dragged on for many years. Agnieszka, can you tell us a little bit about the facts of Doe v. Exxon and how long this has been going on?
So Doe v. Exxon is actually I think, older than my kids. It was filed in 2001. There's close to 1,000 filings on the docket. So it was a ton of work. We originally applied it under the Alien Tort Statute, the Torture Victim Protection Act, and then as an afterthought, common law tort. And then just given how things unwound at the Supreme Court, all the exciting international law claims were dismissed. So no more ATS, no more Torture Victim Protection Act, and we were left with the common law assault, battery, and negligent supervision claims. And those were ultimately the ones that ended up being successful in carrying us through. The DC Circuit held under traditional transitory tort principles and choice of law analysis that the Indonesian law would apply. And so we had to get 7, both sides got a whole bunch of Indonesian law experts. I hired every Indonesian law expert there is in the United States and elsewhere. And so we had 7 separate reports on the content of Indonesian law. We went all the way through summary judgment twice. We went to the DC Circuit twice, went to the Supreme Court once. And, in the end, I guess I should run through the facts first, which is that what the case is about is it was a small group of 11 Indonesian villagers that were living in villages in rural Aceh, Indonesia, which is a rural province in Sumatra. And Exxon had discovered natural gas in that area and had built wells and facilities all around operations, and they contracted with the Indonesian state-owned oil company to provide security for their facilities, and the security that was provided was Indonesian military. And those troops committed, we allege, human rights abuses, rape, torture, murder, and we allege that those were done in the course of their employment. The Indonesian law was a lot like our law of negligence and a lot like our law of respondeat superior agent liability. And so that's what we litigated. And, weirdly, we were one of the big beneficiaries of COVID in that we never were able to get visas for the witnesses to come to the United States. And we weren't able to get visas for the plaintiffs to come to the United States until trial was imminent. But the court, because of COVID, permitted us to take the depositions by Zoom. So we were able to perpetuate the testimony of eyewitnesses for every single one of these events by Zoom, which, honestly, I don't know if we would have been able to do if we had to go to Aceh and spend weeks and weeks on the ground, or if we could have afforded to bring them out to Singapore, Kuala Lumpur. But because we were able to do the depositions by Zoom, we were able to depose over 25 eyewitnesses to the events. So we had really solid eyewitness evidence. Like we had the rice stand lady who saw one of the plaintiffs get beaten up and kidnapped. We had testimony from a kid that was on the rice field that saw his father, he saw his father get shot, and he recognized the soldiers because they were the same soldiers that he had passed on the way to and from school every day. And they had twisted his arm and made him sing the Indonesian national anthem and do push-ups when he got the words wrong. So he recognized the soldiers that shot his father, and the rice stall lady recognized the soldiers because they'd been her customers at her stand. So she knew that they worked at the Exxon plant. So we were able to identify the assailants. We were able to show that, that they were working for Exxon when the torts occurred. And we wrote, a monster summary judgment defense, and I kind of recommend reading this because it resulted in Judge Lamperth writing a tour de force 86-page opinion that marched through the evidence. And he held that Exxon's defenses were largely entirely meritless, and the case settled.
I'm so glad you brought that up, Agnieszka. The evidence in this case, much like the Cisco case when we talked last week, how did you get such extraordinary evidence? The idea that you benefited from COVID and that under normal circumstances, you might not have been able to get this many witnesses to get testimony before the court is just an interesting thing to think about in these cases in general. How are we able, if we had less restrictions and we had less procedural issues, we were able to get a significant body of evidence like this, would we see more success in these cases? I thought that was just it's a very interesting fact about this. One question I wanted to put to you here, there was a statute of limitations issue for some of the claims here, and you all had made an equitable tolling argument that got rejected. So I want to zoom out a little bit from the law and just look to sort of common sense and looking at this from a perspective of access to remedy. It just seems really hard to imagine that most potential plaintiffs, under the circumstances that these plaintiffs faced, would ever be able to find a lawyer in the United States and put together a claim under this very short statute of limitations that we're usually seeing under state law when we're not able to use a federal statute that has a 10-year statute of limitations. So what was the statute of limitations that was applied? Why was the equitable tolling argument rejected? And what impact does that have on these plaintiffs? But how does this also impact sort of similarly situated plaintiffs who are thinking about litigating under state or foreign law in the US?
What I wouldn't take too much away from that, because DC does not recognize extraordinary circumstances tolling. So some of that is particularized to the jurisdiction. Other jurisdictions recognize extraordinary circumstances tolling. And so that was kind of a quirk of DC law.
So did you end up using the Indonesian statute of limitations, or was it the DC statute of limitations, and what was it?
So DC, and in a lot of courts, it's the shorter of the two, where you apply both, and there's some sort of statute. And Kathy, if you want to speak to that at all, but I mean, that is one of the challenges of if you end up using state law or foreign law, that in a lot of places you will end up with a very short statute of limitation because of the operations of these savings statutes.
Yeah. And we'll talk about that more as a group here in a little bit, because I do want to tease out some of the differences between litigating these cases under state/foreign law, since choice of law seems to generally point to foreign law versus using the federal statutes. Maybe first, so there was this settlement. It was significant. I know that's confidential, so we're not going to talk about the specific contents of the settlement. I do want to just point this question, maybe Agnieszka, Kathy, or even Katie. Katie last week mentioned kind of the importance of survivors having their day in court. I know that when I was a law student, for me, I remember hearing about cases and there being conversation of settlement. And I thought, you can't settle this case. These, they need their day in court, and I want to see there be a decision. I think that now I'm a little bit more practical about this because there's a lot of risk involved in getting that day in court. But does anyone want to speak to, just in a case like this, is there an argument for a survivor having their day in court? And what's the argument for settling instead of holding out?
Well, I think in some ways it's sort of easy because it's up to the client, right? Always got to be up to the client. So if you have an offer on the table, you can't think to yourself, wow, I really want that glory of going to trial, or I really want to prove this important point of law. You have to transmit that offer to the client, and the client's got to decide what's in their own best interest. And they're really capable of doing that. And in our case, they've been waiting 21 years for justice, and it was a long time, certainly enough time to get the evidence together. And they felt like they were able to tell their story in the depositions.
That is a long wait. I think that's a great point about the depositions. Katie, do you want to jump in on this?
Yeah, thanks. I've also had the same evolution of feelings about settlement. We litigated on behalf of Iraqis against Blackwater and Eric Prince, some pretty intense litigation, more than a decade ago. And it was a very clear case. And the settlement, it is certainly up to the clients. And at that moment, there was some feeling of, should we have pressed on and gone to trial? And then we also settled on behalf of 71 Iraqi former torture victims in a parallel contractor case to El-Shamari. And by that point, I was a little bit, okay, they want the settlement, let's do this. And now, with another 12 years of litigation in El-Shamari, despite so many wins, the fact that we are still only on the brink of trial and who knows what can happen, I think for our clients, and Agnieszka, a question for you really, when you were talking about the son who saw his father, when we're asking people to bring back really some of the most painful, if not the most painful and traumatizing moments of their life, decades on, as they've tried to rebuild and move on, it is really, really tough. And I think that is not always appreciated in kind of when you said, Agnieszka, the glory of trial. Like, there's such an important moment in people being in court telling their story. But I have also found that the depositions are a incredibly gratifying moment for clients. And after those are done, this huge sense of relief and empowerment that they told their truth and answered the questions and faced the other side. So I have found the depositions have been far more impactful for clients than I appreciated going into them.
If I can add to that too, I mean, it's something that I think about a lot, just in terms of like when you're negotiating a settlement agreement in general, obviously I'm not speaking about any specific agreement, but just in general, there's always a tension between the company wanting to have you never speak of the case again and like your not just duty to the client to make sure that they're not being silenced, but also to the larger movement and to their community. And so that can be a really difficult tension. So it's definitely something to think about. I mean, I think just as everyone said, it's the client's decision and there can be a lot of good coming out of settlements for sure. But you also want to make sure you're not just totally giving away this right to speak out in the process.
Great, thanks for that, Kathy and Katie also. So I'd like to shift just a little bit and zoom out on, instead of talking specifically about Exxon, and think a little bit about litigating cases under state law / foreign law. There's actually, I think we often think about just these big federal statutes because typically, though this isn't entirely true, but typically folks in our community are not filing cases initially in state court or in federal court under state law. We're usually filing these cases under federal statutes that might have some common law claims added on. So at this point, post-Kiobel, I think there's been maybe a lot more experience litigating these state law claims or foreign law claims. So I'd like to sort of tease out for the audience, what are some of the advantages and disadvantages of litigating under state or foreign law as opposed to under one of these federal statutes? We have talked a little bit about the statute of limitations. You're typically going to have 10 years under the ATS, TVPA, TVPRA, and much less under state or foreign law. What other advantages and disadvantages might exist for each? I don't know, Terry, we could start with you. I know that there are some state law claims in Cisco. Do you want to speak about what the status of those are and what potential you see? You're muted, Terry.
Computers. So basically we filed the case under the ATS and the TVPA and also under state law claims, battery, assault, false imprisonment, and unfair business practices. And we thought of, well, let me put that aside for a moment. And so the district court declined to exercise supplemental jurisdiction over the state law claims after wrongfully dismissing the federal claims. So that's where things are. And if the case goes back to the district court, then, with the federal claims intact, then the state law claims would be reinstated. There was some discussion as to whether we should just file, a state law complaint while the Supreme Court was chipping away at the ATS. And there have been quite a few litigators who have published articles contending that the ATS is over and go to the state law claims. And we actually have a state law complaint that we didn't file. And the decision was simply to keep going, especially because we hadn't yet reached the Ninth Circuit. And during the first oral argument at the Ninth Circuit, Judge Berzon was so supportive and understood so well, the facts and the allegations. I mean, it was mind-boggling that we decided to simply go ahead with the federal claims. So we haven't fully litigated the state law claims, and I'm not sure if there are cases where the state law claims have prevailed. I don't know of any, but the other panelists may.
Great, thanks, Terry. Does anyone else want to speak to thoughts about litigating these claims? I know that, in Chiquita, there's claims that are being litigated now under Colombian law. Exxon, state law claims were litigated under Indonesian law. In Cisco, it sounds like they have not done this choice of law analysis, but who knows, it could eventually point to Chinese law. What is your experience litigating under foreign law, and how's that? Are judges able to understand that and work with it? How's the experience for the litigants?
I think KBR case we had against KBR, Halliburton, and Dawood and Partners, who are U.S. military contractors that we alleged had benefited from trafficking in persons of Nepali men from Nepal to U.S. bases in Iraq. We also used Iraqi law in that case. And I think judges are able to navigate it. The laws really aren't that different. Like the law of negligence in Indonesia is not really that different than the law of negligence in it's not a surprise, right? It's all the same. There's differences at the margins, but the core of it, every country has that concept of negligence and negligence supervision. And in fact, sometimes it's stronger and broader in other countries. The statutes are more protective of human rights, and the statute of limitations is longer. Under Iraqi law, it was 30 years, and so much longer. So I haven't found that to be the sticking point. It does make it more expensive because you have to get experts, and there's always kind of a battle of the experts about what the law actually says. But I think judges can do it. It's not that hard.
And I just add, I think one of the areas that is still maybe ripe for a little more exploration is customary international law or human rights law in state court, because going back to the founding of the country, pre-ATS, there was some existing common law that was reflective of customary international law. So trying to bring that into state court is one area. And then the other is we've seen a lot of states and municipalities implementing human rights law into their own laws. So I think that that's another area where maybe, especially I'm looking at my own self here, some of us who are more comfortable or used to being in federal court need to really look more broadly. And I know out in California with the business laws, you've all been there. I think there's, again, some research and possibility using human rights law at the more local and state level.
Great. I think, that point you're raising, Katie, about folks in our own field, whether or not we all feel comfortable or have the expertise to bring this when we're used to litigating in federal court under a federal statute where we kind of can get a sense of the case law. At least to me, I think you're, imagining litigating something under Chinese law feels hard. But, to Agnieszka's point, there could be some ways in which it's more human rights compliant than some of the statutes that we have here in the United States. So there could be some advantages there. So somewhat related to this, and I'm seeing that Erin Halegua, who is probably almost an expert on Chinese law, says it's often great, which is a great thing to throw in for you, Terry. So another thing that's kind of somewhat related, just zooming out even a little bit more. So, we've talked in this series about the Alien Tort Statute and the torture statute, trafficking statute, state law claims. So imagine that I am like an international legal expert, and I'm looking at the extent to which courts in each jurisdiction are providing meaningful access to remedy. Maybe I'm looking at the UNGPs, and I'm trying to figure out which jurisdictions are really providing access to remedy to victims. I'm looking at the United States and Canada and the UK and Argentina and South Africa, and I'm just trying to figure out what is a good forum. Do we think that the United States is a good forum? If so, why? And if not, why not? I know this is a hard question. Kathy, take it.
Well, I think there's just in some ways, there's a moral necessity that the US continue to be a good forum, because we have a lot of very powerful companies that are doing things all around the world. And I think last time we were talking a little bit about the safe harbor for violators and how we don't want to become a safe harbor. And it's really important that we are able to hold our own citizens, and I'm talking about corporate citizens in particular, to account in terms of what they're doing around the world. So I think, on a moral level, it's really important that the US continue to be a good forum. And then on a practical level, a lot of companies do hold assets here. And so even if you get a really great decision in another forum, you're going to need to enforce that decision in the United States. And so there's a way in which it does make sense to bring these cases here, because we want to, if we get a good judgment, be able to enforce it without going through another proceeding necessarily.
Great, thanks, Kathy. Do others want to weigh in on this question? I'm curious about how others might fall.
I can just, oh, whoops, I have to
Yeah.
unmute. I have to figure
Not
out,
on me. You can go ahead.
let me,
Terry, you just muted yourself. You were unmuted.
there we go. So there are a few cases that I litigated here in the US where I also litigated with a team of lawyers in Europe, Argentina, Spain, France, the UK. And that was very satisfying. And the cases in Spain and Argentina lasted longer than the case I'm thinking of lasted here, because of universal jurisdiction. And I don't know, there were maybe other considerations. The judges seemed a lot more inclined to follow their moral compass as well as the law. So, and I think for Uyghur, for Uyghur cases, there have been quite a few cases in the Netherlands, France, and so on, because the law allows one to ask prosecutors to carry out the cases, and that's also an advantage. So, I mean, I quite enjoyed working, globally, although I agree with what Kathy said, that the United States, should not be a safe harbor, and I'd like to see cases litigated here as well.
Yeah, just on that, there's something very bizarre if a corporation based in Arlington, Virginia, can go into a court down the street and argue for breach of contract around something with its operations in Iraq. And then when it comes to universally recognized conduct like torture, suddenly say it's not okay to be in this US court. We can't have that. And I do think that there are also some positives in the US around discovery rules, and the fact that plaintiffs can file a case as long, of course, that it's not frivolous, and you don't have to pay. I mean, you in other jurisdictions, particularly some in Europe, if you lose, you have to pay. And that is a real disincentive to bring what might be complex cases, even if they are correct and righteous and the facts are there. That doesn't mean that you can always make it all the way to the end in a successful way. So the fact that plaintiffs can come into a US court, file a case, and put forward their side against a powerful actor, I think there's a lot to be said for that. But I really also echo what Terry said about not being too narrow and how we're looking. These are multinational corporations, so they do have presences in more than one country. And now that there is an increased corporate accountability set of laws globally, we don't have to make that choice. It's not about one or the other. And unfortunately, there's a lot of bad conduct that you can have parallel cases without having the same facts in multiple places, but you can really be looking at different aspects of harm for a single company in multiple places.
And just to tee off, like Katie said, I think it's easy as American lawyers to really only look at what's happening here, but they're like the EU has terrific jurisdictional principles. There are great lawyers all over the place bringing really interesting corporate accountability cases. There's the Nefson case in Canada that was settled that had to do with a mining operation in Eritrea and abuses in Africa. Lawyers in England have been bringing really terrific cases involving forced labor overseas and parent liability over subsidiary conduct in Africa in a wide range of contexts, and doing it successfully, and have really kind of done great work on both sovereign immunity and corporate form and accountability. Lawyers in France have brought terrific cases against Lafarge for conduct in Syria. In fact, I think there was just that indictment that is not just the indictment of Assad just the other day for his conduct. So there's a lot going on in other countries. And I think in the ideal world, people would be able to bring these cases and get justice in their home communities. But we're just not at that point yet in many countries. And particularly for victims of human trafficking, that's really hard. Like for our Nepalis, like the defendants were never in Nepal. Like there was no jurisdiction over them there. They were brought to another country and then a third country. So there was no opportunity to file a suit in their home state or where the tort occurred. They really had to file it here. And as Katie said, there should be nothing unfair about filing a suit against the defendant on their home turf. But I think for a lot of victims, it just would be better and easier if they could file in their home jurisdiction and could get justice quicker. When I think of the Exxon plaintiffs, I think they would have probably been happier with a tiny settlement right after it happened, so that what they wanted to get out of the case when they first filed it was they wanted to pay the school fees for their kids and be able to feed their families. And they went through 20, like they didn't ever send those kids to school. They didn't get the school fees. Kids didn't go to school. Like all those bad things that unrolled from that happened. And by the time we settled the case, like those kids were already grown and they didn't go to school and they didn't have the lives their mothers hoped for them. And I think that's kind of the frustrating thing for me. I think it would be better if we could settle these cases more quickly, more locally, but we're not at that point.
Yeah, that's such a great point, Agnieszka. You think about the Vedanta case in the UK, and you think about Nevsun in Canada and all of these cases, but also about Nkala in South Africa, this big class action case against the gold mining sector that resulted in this huge settlement for workers under apartheid in that country. And so you do see some cases increasingly being filed in the place where the harm occurred, but it just depends a lot on that particular forum, on the independence of the judiciary, safety for witnesses and litigants. So I think it's something that if we can continue to not just assume that global South jurisdictions are off the table, but think about how can we make sure that we always consider them an option, but recognize that maybe it's not quite there yet. There are a lot of advantages to filing in those jurisdictions, I think, for litigants. So I think that's a really important point. We have some questions rolling in here, so it's almost question time. I think maybe we should jump straight to questions from the audience because we were a little constrained on that last time. I'm going to start with, this is a question for probably Agnieszka or Kathy. This is from Lincoln Ellis. Assuming the congressional clarification of the TVPRA is not retroactive, going forward, would you have a case against Rubicon if the same thing happened now after amendment to the TVPRA? I'll let either of you handle that.
Yeah, I think it's very clear going forward, right? I mean, there's no question in the language that Congress passed. So the question in our case right now is just, is this clarifying such that, the court should hold that it was that way before and it is now clear. That's the question in our case. But regardless of what happens in our case, it'll still be a good tool for people going forward.
But we do think that it is clearly clarifying, which it says right there in the title, clarifying. And a lot of cases have proceeded with attempt or conspiracy liability in other jurisdictions. So it's particularly important that, we establish that it's clear that it was always intended to be covered and that amendment was clarifying in order to preserve all those other cases that are pending elsewhere.
Great, thanks both. My next question here is from Emily Ray at Harvard. She's a clinical fellow with one of the new clinics there. She says, because the cases we're discussing generally involve internationally based plaintiffs, how important is it for U.S. lawyers to have strong connections with domestic attorneys in those international jurisdictions? More generally, how do you think about building your team for these cases? I wonder if a couple of different folks want to answer this, because I think this is a really good question that hits on every case that probably everyone here has litigated.
I could
I
speak.
can start. Oh, you could go ahead, Terry.
Go ahead. You.
Oh, you're Terry. You are now muted. You were unmuted.
All right. Well, I can just start off while Terry unmutes, and which is to say that I think you really need a strong local team of lawyers and community members. Otherwise, you can't succeed in these cases. Yeah. That's all.
So I was just going to add that the lawyers in China, I actually met with the lawyers in China like at 4 a.m. in a secluded location in Washington, D.C. and gave them evidence so that they could file cases. And then what ensued, one of them was Gao Zhishan. I don't know if you followed what happened to him. What ensued was that, and they told me, by the way, so during the meeting, they told me to be careful. And I said, what about you? And they said, oh, we're princelings, meaning, you know, the princes in the Chinese Communist Party, they're safe, everything is fine. And within maybe 3 years, they were all being arrested and tortured, and they all look 20 years older. It's so that's not an option. Obviously, that's not an option. It would be a nice option if it were, though. I also gave persons in China complaints that they could file, but it was the same result, and so I'm not doing that anymore. But that's China, that's not everywhere else.
Thanks, Terry. Katie, do you want to jump in?
Yeah, I think you have to be prepared before you file these cases with a huge array of context set up. And that includes not just the community members and the lawyers that Agnieszka very rightly said, but your kind of go-to trusted person, because especially cases, whether it's in a closed country or whether it's in a war zone country, you need someone who is able to get in touch with your clients and help. There's a ton of logistical work in setting up meetings with clients, whether in country or in safe third countries, and just building that into your prep. And that is a piece that it has really revolutionized over the 17 years I've been at CCR. It used to be so expensive for every single phone call and so difficult. I mean, I remember when Skype came into being, and it was just amazing that you could do a free call. And now that we have something like Signal or WhatsApp and Proton Mail, just the access not only to your trusted team members on the ground, but even to your clients with Google Translate and so forth. There's a lot more direct contact that I feel I've been able to have in a deeper and more meaningful way. But then you still have to have that larger network that was asked in the other question, because whether it's on amicus briefs or whether it's understanding where certain legal trends are going, which some judges in the US will want to know about, you really do have to be tapped in at multiple levels. But it's impossible to do these cases, and it shouldn't be done unless you have that contact set of people, including if there are human rights organizations or activists as your guideposts. Yeah.
Great, thanks, Katie. Our next question is from Rebecca Roosevelt from GLJ ILRF. She asks, how do you foresee the U.S. maintaining that access to remedy and upholding of foreign decisions against corporations under human rights due diligence laws, like France's duty of vigilance law or Germany's supply chain due diligence laws? So I think what this question is we've got this sort of new legal regime coming in Europe that maybe is going to increase liability for corporations. What do we think about the ability of the United States to enforce those judgments here in the U.S.? Maybe presumably if there is a decision against a U.S. corporation related to one of those new laws, is the United States going to enforce that judgment? Do we see any concerns there? An interesting question that I've never thought about. Has anyone here thought about it?
I would say that, this is a very off-the-cuff answer. I don't think I'm an expert in this area at all. But just, I think usually enforcement decisions turn on the fairness of the forum underlying the judgment that is being enforced. So I don't think the content of the laws should dictate whether or not judgments are enforced in the US. It's really about whether there's enough due process and there's enough fairness in the home forum. But I'm not familiar enough with the due diligence laws to know what kind of decisions we expect to see coming out of that. I know there has been some concern about whether they might actually walk back some of the tort decisions by being a little bit less forceful. So I think that's a question.
It is a really interesting question, which maybe Thanks for taking a stab at that, Kathy. That was helpful, and maybe this deserves more exploration. I have another question. This one's about ecocide, which maybe, I don't know, Kathy, is this your topic? If anyone has any particular ecocide background, but this question is, if we see an international consensus on the crime of ecocide crystallize in the coming years, do you see a path forward for viable ATS cases against US-based oil and gas companies for climate harms?
I mean, there's so much wrapped up in this question. So I can say a little bit about ecocide. I'm not working on this issue, but I know people who are, so I might be getting this completely wrong. But I think one of the criteria, this is really something that's being built into international criminal law, and the criteria for the statute would be at a very high normative level like that in terms of a widespread and systematic violation. It would have to be, you know, a standard that's like really high level. So you know, I really can't, it's hard to just an abstract answer whether or not we would see a company being held to account for it, because it's hard to say whether or not, like, it's very specific to the facts of the violation, right? Like, it's going to be, if this really rises to the level of what would be equivalent to a crime against humanity, except on an ecocide level. So, for example, one of the crimes that is, I think Ukraine is pursuing a ecocide claim domestically about that dam that was destroyed during the war. So that's one of the very first instances of this being prosecuted, I think. So it's definitely developing, and eventually may be like specific and universal, yes. But you know, we're just seeing a real development of the law in this area.
Great, thanks, Kathy. We're almost out of time. I'm going to do one more quick question because I think it's kind of interesting. And if one person could answer this, it'd be great. This person says, I'm also interested in hearing more about the idea of leveraging customary international law in state courts for international plaintiffs. It seems like diversity jurisdiction could be a persistent hurdle, allowing for removal to federal courts. Are there ways you see to get around this? And maybe as a side question of my own, is it desirable to stay in state court, or do we want it to be removed to federal courts? So is there a way to get around this? Any historical examples of US-based plaintiffs leveraging international law in this way that we can look to? Who can answer this one?
I can't answer it in its completeness, but I'll give some way in. There have been a couple of cases, and I think Terry Collingsworth had brought a case under customary international law. I forget whether it was in Montana or Missouri. It was in an unusual or an unexpected jurisdiction, and I do believe it was removed to federal court, but state law still applied, if I'm remembering correctly. And I think there is further exploration of this as a possibility, in part because of some of the limitations that we're seeing on federal law, at the federal court level. But I think it could be very interesting for a state court judge who has a lot of constituents who are passing laws who are saying human rights are our values, and we don't want, whether it's an environmental violation, or whether it's a labor violation, whether it's torture in a local detention center. I don't think it has to go to a federal court. And I'm not sure that every state court judge at this point would feel like it should either. So I do think it's an area for more exploration.
Great, thanks for that, Katie. We are out of time. I think we could talk about this for 5 more hours. These cases have been so fascinating. First, I want to thank Kathy, Agnieszka, Terry, Katie, and Paul in his absence today for his participation in the last session, for all of your extraordinary contributions here and very insightful comments. I also want to thank all of our participants. You had a lot of really interesting and great questions that are at least giving me some food for thought. And there's more questions that we didn't get to, but we do appreciate that. I think each of our panelists, you could probably email them questions afterwards if they did not get answered today. Again, this recording is going to be posted on our website. We'll also be emailing it out to everyone who is registered. If you don't get that, feel free to reach out to us and we can help you. Thank you all so much for joining, and maybe we'll do this again next year. Thanks, everybody.